Stay with that story. Now I'm joined by Bongiwe Mbinqo-Gigaba, chairperson of Parliament's Portfolio Committee on Basic Education, as well as South African Communist Party Central Committee member, Dr. Alex Mashilo. Good evening to you, and thank you very much for your time. Ms. Bongiwe, let's begin with you. It seems that the regulator sat with the Department of Basic Education and informed them, before we went to court, that publishing of these results would not be in contravention of the POPIA Act because the information was sufficiently de-identified. Why do you think the department still went ahead with this decision?
Good evening to you, and good evening, Dr. Mashilo, to yourself as well. Look, I think the department has done that to try to protect what the department thought is the personal information of a child. I think that is the reason that they went ahead with that.
And then, having gone ahead with that, they go further, not to go and protect that decision, or at least defend that decision in court, and decided not to challenge this application. It seems to me that they are contradicting themselves on the one hand, to say, well, we do believe that this is the right thing to do, but we're not going to go and defend it. What is the rationale behind that? No,
remember, there was no decision of the court then. Now, today, there is a decision of the High Court, and it is just right that the department must abide by that decision. And I don't think it's in the interest of the department. And remember, I'm not talking on their behalf here. I'm talking as a person that does oversight as well on them.
Yeah.
I don't think it's in the interest of South Africans to delay the results of our children. So I think the decision they have taken to abide by the decision of the Pretoria High Court is the best decision for the country.
The decision was not really about delaying. The decision was publicizing whether or not they should be publicized. And they did not go to court. They went to not defend that. They didn't challenge it. The parties brought it, AfriForum brought it. They didn't challenge and defend their decision.
But that is the judgment of the High Court, right? Now, there is no reason, in my view, for them to want to challenge what the High Court has made a judgment on. So hence I'm saying to you that as a person as well that does oversight on the department, I think the decision that they are taking not to challenge what the High Court has decided on today, it's the best for the citizens of this country.
All right. Dr. Alex, what is your feeling? Is this the best decision not to challenge the outcome of the High Court?
Firstly, the Department of Basic Education might lack a legal standing or a locus standi because they did not go to the court to defend their decision. Having not appeared in court because you decided to not defend the decision, you will have a problem if you want to challenge that decision. While when you had an opportunity to go and present the reasons for the decision that you made in the first place, you decided to not do so. In the language of football, today's court judgment was actually a walkover. Like if there is a match between two teams and one team decides to not appear and the other one wins the match, that is a walkover. The Department of Basic Education communicated to the country last week, informing all of us that in line with the provisions of the the Protection of Personal Information Act, they will not be publishing matric results with learner details in the media. We welcomed that decision. I must say that we noted what the department said today, that they consulted with some stakeholders, but some of us, like the SACP, who welcomed what we believed was a good decision that they made were not consulted when. This is why we said today, in response to that judgment, that we, among others, will seek an engagement with the department to understand the reason why they took a decision, and when they were challenged to go to court to defend that decision, they decided to not defend that decision. By the way, your question relating to the regulator, we followed the statements made by the regulator in the interviews, particularly the interviews offered by Advocate Pensita Pula of the regulator. One of the things that she raised was that you are dealing with personal information here. This requires training. Particularly, we were interested in the point she raised as the SACP, that you will need to consult with the learners. These are young people. Of course, their families, their parents or guardians about publishing their information and giving them an opportunity to object to the publication of that information.
Yeah.
We are not sure whether the department has satisfied that. And let us deal with the issue of
But Alex, that is coming at Dr. Alex. The latest statement from the regulator via Alison Tilley saying that they agreed with the department in that meeting that the information that is contained is sufficiently de-identified. So it's a student number. That's all that is there. It's sufficiently de-identified, and it will not be in contravention of the POPIA Act.
You are right. That is the recent statement. That is today's statement. We are referring to the statements made by the information regulator ahead of this court process. By the way, you and I passed through the Matric process, right?
Yes.
We know that there are situations where your identity number is your examination number, isn't it? So,
in some instances, I would want to agree, yes.
Yeah, we live in the digital age today. Think about your identity number, which is your examination number, published in the media, and we live in the digital age today, where people can crack these numbers and identify who this number belongs to, and they can harvest that information by unlawful means and then expose. This can lead to many exposures. So we must not talk about the examination number as if we did not do Matric ourselves, as if we do not know that there are circumstances where your ID number, which is a serious personal information, is your examination number.
But what if the experts on the issue are saying that we had a sit down, we are advising you that this number has been sufficiently de-identified?
That your ID number has been
it is not your ID number. It's a number that they have generated as your exam number, which is not your ID number in this particular case.
What if your exam number is your ID number, as it has been the case?
This has not been the case, I'm told.
It has been the case.
It has ceased being the case for a while, in fact.
I'm sure you have gone through the Matric.
Yeah, in my time, this was long ago. Yes, it was. It was the ID number.
Examination number. There is an examination number and there is a center number.
Yes.
You can harvest the numbers, and I repeat, we are living in the digital age here. Technology has advanced.
Right.
There are many things, even heads of states are hacked these days, right? And you and I know about this. Even heads of states of advanced countries.
Right.
So we need to take this seriously, taking into account the context and the age we live in.
So in your argument, you expected the Department of Basic Education to go to court and raise these issues in challenging this application?
See, if the Department of Basic Education exercises due considerations before it makes decisions, it convinced many of us when they issued a statement that they will not be publishing the results, isn't it? And we believed in the department. So when the U-turn came about, that caused a confusion. Why could the department that we believed in embark on such a U-turn without giving the details?
All right, let's take a break. We'll get into that a little bit more when we come back. We have with us the chairperson of the Portfolio Committee on Basic Education, as well as Dr. Alex Mashilo of the SACP. Do stay with us. In Focus continues next. Continues, the chairperson of the Portfolio Committee on Basic Education, Bongiwe Mbinqo-Gigaba, as well as SACP's committee member, Dr. Alex Mashilo. It's still not clear to me why and how you as the Portfolio Committee feel about the Department of Basic Education not going to court, as Alex puts it, to protect its initial decision. Now you have a court ruling, which they were not a part of, in a sense, because they set this one out, as Alex puts it, it was a walkover. And now we have a situation where, if the SACP's view is taken into consideration here, digital information can be harvested on the students because it's been made public.
Look, I really think that, and I would keep on reminding you that I am speaking as somebody that does oversight.
Absolutely.
And to me, I represent the public. So the judgment of the High Court, I don't think really, where am I now as well? As much as I supported what the department have raised last week, but now that there is a ruling, I really think, and I stand by that, I really think that it is right. It is right that the department must abide by it. And I'm speaking on behalf of the people that I represent. Yeah. It is in the interest of us not to challenge what the courts are standing for. It is not. It is in our interest actually to respect the judgment of the courts. Yeah. So the fact that the department has decided to abide by that, and as I am saying, if the department had taken a decision today to appeal that judgment, meaning that we were going to delay the announcements of the results, and that was going to delay the children in their registration to continue with their studies. So really, in my view, as the chairperson of the Portfolio Committee, that is Parliament, I think they have taken the right decision not to really challenge it.
Yeah, I don't think anybody disagrees with you in as far as obeying decisions of the court. We park that. We are all in agreement that the decisions of the court have got to be respected. But the issue at hand here is around the matric results being publicized. What's the view then of the Portfolio Committee on this particular matter? Is it in the interest of the learners that the outcomes of their matric examinations be publicized?
Look, that of course would depend, and that would depend on something that has been researched, whether they agree or don't agree. But I think the department has taken a decision that they won't publicize that anymore because of the research that they have made as the department, because they wouldn't just out of the blue wake up and take such a decision. And I'm raising it as a Portfolio Committee chair that has not really had a technical report from the department. That is the research that I'm referring to. So I think based on the incidents as well that has happened in our country, which we all know that some learners, they even committed suicide because not their ID numbers, but their center numbers were there, you know. So I think it is a decision that is a combination of many factors. And they have taken that decision, and like me and you agrees now, there is a court judgment, so they need then to abide by that.
Yeah. As the lawmakers, I mean, you are MPs, so you make the laws. That means you would need to come up with a better position in law that would be able to protect that information if you so strongly believe it should not be publicized.
And you know, there are three arms of states. And of course, the courts have done their work onto this matter. If it was us, if it was me, of course I would continuously say that let us protect the information. Let us not publicize. But the reality, there are three arms of state here. There are three arms of government here, and that is actually what we need to understand. And we need to respect each other so that we are able to work with one another.
Right. Dr. Alex, is it water under the bridge? The courts have decided, and that will be the end of it. Henceforth into perpetuity, Matric results will be publicized?
No. The decision of the High Court is not a decision of the Supreme Court of Appeal. It is also not a decision of the Constitutional Court. So there are possibilities for this matter to return to the processes going forward into the future. For example, if my child was doing Matric and the department did not consult me about publishing their results in the media, and I was not given an opportunity to object to that, I still reserve my right to challenge that decision. Let us say this. If the department went to the court to defend this decision and was not happy with the outcomes of the decision, it reserved every right in this country to challenge that decision. And challenging that decision was not going to delay releasing the results to the learners. Remember this, no higher education institution, no college that practices good governance in this country can ever accept a newspaper clip or a media clip as the proof of Matric results. What institutions of learning, higher learning and further education and training, or technical education and vocational training require as proof of your Matric results is your valid statement or certificate, right? If you apply for a job, they want your valid certificate or statement. So the results in the media are not the proof. That's why even if they are published, you still have to go to the school to obtain a statement. So the result, the release, the court process was not going to delay the release of the results to the relevant people or to the relevant persons, being the schools and the learners. That process was going to take place. Now, what we have said today, and I quite like what our leader from Parliament has just said, because she has a very difficult task. She represents the public, but the public is not of one view. There is AfriForum and there is the South African Communist Party. What we are saying are the diametrical opposites of one another. So how you represent the public is quite a very difficult task, because it is a task that has to take into account the contradictions that are there. As the SACP, we do not agree with the AfriForum. Okay, so the public is not a single entity. It's not a homogeneous entity. It is a heterogeneous entity, and we are quite happy that from where you stand, you really share our view. So we just hope that the department did its work and was able to go to the court to defend its decision. And we will quite like, because you are aware, you are our representative, you are aware about the problems. The results can be published. Tomorrow, the same media will be running news. So and so committed suicide. And there cannot be one life that will come two times. That life will never be recovered. What happens today and the publication of these results will never recover the lives that will be lost due to the psychosocial distress that can even cause the suicides. Life to us comes first. These are the considerations that the court was denied access to, because the court had the only one side of the story and made its judgment based on that side of the story without the other side defending its initial decision. We have to appreciate that.
Ms. Bongiwe, the courts only had one side of the story without appreciating the other side that Alex is raising, the psychosocial implications of a learner getting their results publicized, and they are actually not good results. Would you support a call to take this further to the Supreme Court or even to the Constitutional Court as Parliament playing your oversight role?
Look, I think I stand and by the decision that I've made that we wouldn't not support what the department has done last week. Actually, we supported it, and we never had an issue with it. Now that there is a court judgment, and I do take note what Dr. Mashilo is raising, and I think he is also raising realities that happens. But the department, I think it is again in the best interest of our children that let's allow it. Let's allow probably this to pass, because you would appeal this and unnecessarily put everybody. And I still remain, because if the department would have appealed, the reality is that after appealing, you would have to wait for the other court then to take another decision. And that delays, I mean, there is no other word you can put for that. That delays for children, and we're talking about, like I've said, we are representing everybody. There are children now, our children, we know they are waiting for their results on Thursday. And that would have delayed that. You are getting that judgment 2 days before the release of the Matric results. And be that as it may, and at a personal level, even if I would say now, I also think that the department would have appealed. But now there is a bigger picture. And like I have said, I'm not speaking for Bongiwe here, but I'm speaking as a chairperson of the portfolio committee, which represent the entire country, the AfriForum, and also everybody, not necessarily the South African Communist Party. Now that there is this judgment, and we are 3 arms of government, and we are 3 arms of state, I mean, we would have to, let's just support that the decision that the department have taken, and allow it like it is. I don't want to go into the issues of digital, the issue of the IDs, whether the de-identification, like you have said, that will be there or not there. But let us just look at this decision, and now that there is a department, which I cannot speak on their behalf, they have taken this decision. I think that we just need to respect the fact that they have taken this decision, right, as well.
Appreciate you both, and thank you very much for joining us tonight here on In Focus. That is the chairperson of the Portfolio Committee on Basic Education, Bongiwe Mbinqo-Gigaba, and SACP's Central Committee member, Dr. Alex Mashilo.